State your names.
Do you want it?
Gil Stanford.
Okay. Mr. Stanford, what is your claim at this?
Damages to the property.
How much are you claiming?
How much? Yeah, the damage I'm claiming is $7,138.17. Lesser deposit $1,050. So the balance $6,088.17.
And Ms. Norman, your position on this is all of that was waived in the previous proceeding.
And also my security deposit, that's an incorrect amount from my standpoint.
But as I was to understand this from before, and I certainly will have a trial on the issue, but I don't think it's going to be necessary. He was going to keep the security deposit, but there were going to be no other claims.
No,
No? Go ahead. What did you think was going to happen with the security deposit?
well, I did on that day in October of 2024. After that was over, I did submit an address for him to send my security back, my security deposit back. And then I got the damages. Yes. I actually thought the case was over from that day moving forward as far as any claims, since he did waive those in this court. But yes, I was definitely under the impression and that I would have my security deposit returned.
Is the amount that you're claiming, Mr. Stanford, is that rent?
No, none of it is rent. I waived the rental dollar amount that we had talked about previously.
Have you sent to Ms. Norman what your claims are for security?
Yeah, she's gotten
Well,
documentation on the repairs and it's just showing all the damage and all that.
and all of those have been done?
Pardon me?
All of those have been done?
Have been repaired, yes. That was all repairs before a new tenant moved in.
When did you move out?
October 31st of 2024. I moved in March 2020. And respectfully,
Go ahead.
Mr. Stanford, there were several issues with the property, which I reached out to Isabel Township, to Frank Daniels, and asked for inspection, and that was
Because he didn't have a COC.
Well, because the property had leaks
Right.
everywhere, so I reached out, because Pittsfield Township said that I could do that as a tenant. And that's when I found out he didn't have the certificate of occupancy and all of the repairs that needed to be done. And I do have that report with me today.
Which report?
The report from Pittsfield Township with all of the uncorrected issues at the property.
So it would seem to me, as I look at all of, I have the transcript from the October 22nd, 2024 hearing. And part of the issue that I see is that there came up this water bill and some other things, but you never had a certificate of compliance on the property.
Because of a oversight on the Pittsfield Township Building Department.
But you didn't have a COC.
I did when she first paid about $4,000 towards the initiation of the lease.
Do you have proof of that?
Yes.
You have it with you?
Yeah.
But then it expired.
Pardon me?
Then it expired?
And then it expired because the township failed to do what they are required to do by statute, sending out a letter initiating the process of renewing the C of C is what they call it.
But she paid rent while you did not have a certificate of compliance.
She paid money.
No.
Yeah, she paid the money
right.
during that time.
She paid rent while you did not have a valid certificate of compliance.
Yes, and that was
How much did she pay when you did not have a COC?
the I submitted that to the court of the payments that she made. Let me get a copy here.
I have a letter.
She had paid. Well, Your Honor, I objected. This. Let me just.
You can object all you want. It's my question. Overruled. Answer my question.
All right. She paid on May 1st, $2,000. On May, or it's 2024. May 13th, she paid $2,000. On May 13th, 24, $231.01. And on May 28th, she paid $2,000.
And all of that time she paid, you didn't have a valid COC.
Because of the failure of the
Didn't ask that.
Pittsfield
You
Township.
did not have a valid COC.
That's correct.
And you understand without a valid COC, you can't charge rent.
Well, there is a court case, Norton versus Southern Utah Wilderness Alliance, 542 US 55 in 2004. An agency action unlawfully withheld or unreasonably delayed. A claim can proceed only where the plaintiff asserts that the agency failed to take discrete agency action that is required to take. They were required to start that process
Okay,
COC.
but that's your claim as against, that may be your claim as against Pittsfield.
That's true, but reasonable decision.
But you can't, but you can keep going with the law with me if you want. We can go for, I can go for days. That pertains to your claim if you had one against Pittsfield.
I understand what you're saying.
Okay.
Let me continue here. Procedure of due process must be evaluated using a balancing test that accounts for the interests of the affected individual. The interest of the government is limiting procedure burdens and the risk of erroneous curtailing individual interests under the existing procedures, as well as how much additional procedures would help reduce the risk of error. I've already forego $19,000 in rent, and I don't believe.
What was I supposed
Township,
to take? What was I supposed to take from your reading of that?
that the courts cannot use the failure of Pittsfield Township as a burden against me failing to have this thing renewed. If they had done their job, I would have had the process going to have this renewed. They failed to do that, and I should not be pay the burden of that they failed to do their job.
As to whom?
As to me, should it be totally on my shoulders?
Hold on a second. Hold on a second. But the burden is not just yours; it is also Miss Norman's, isn't it?
Well, when you say burden, I'm not quite sure what you mean by that. They failed to do their job. It put me in a catch-22 situation where the C of O expired, and I wasn't aware that it was about to expire. And now,
how would you have had notice that it was about to expire, since they expire every 2 years?
I would have known that if they had.
No. You would have known that from the first one, because the law, it expires every 2 years.
That's the way it goes. Yes, but the procedure.
So why wouldn't you have been placed on notice that it expires if it expires every 2 years? Why do you need a notice from Pittsfield to tell you that?
Because it's something that for 35 years I've been a landlord, and that's the procedure that these government agencies do.
But you know that it expires every 2 years.
And I was not paying attention to that.
And okay, and that's a different thing. You weren't paying attention. Moreover, with or without the notice that they would send, you could have initiated the renewal of that COC.
I could have. I was
In
busy,
fact, if you were paying attention, you could have done it.
and I was busy preparing this property for re-rental, doing maintenance and repair works and getting it ready. So I was quite occupied with that. I wasn't. I didn't.
Yeah, but that's you. That doesn't mean that you couldn't have done it.
That's true.
So why then would that case that you cite be applicable? Because it's not just your burden, it also becomes Miss Norman's burden if Pittsfield didn't do what they were going to do.
I guess you could say it's both of our burdens, because it put both of us into this situation. She wouldn't let me come in and do the repairs. I couldn't, get the C of O inspected, property inspected to comply with that ordinance. And that's why at that time it stretched on for.
So you were trying to do the repairs because you had to get the CO.
I was trying to
You had to get the CO.
get the inspections done.
Regardless of whether or not Pittsfield sent the notice, you knew that you had no CO.
No, at the time I signed the lease, no, I did not realize that. It wasn't until after,
Why didn't you realize that?
because I was busy with the trucking that before she moved in. And then after she moved in, I was occupied with some of her complaints and demands.
That doesn't make any sense to me. If you applied for the certificate of occupancy 2 years prior, or at least it was renewed 2 years prior, why wouldn't you know that you don't have the CO?
Because I don't have a system put in place to red flag that this.
So whose fault is that?
Is that,
Whose fault is that?
I didn't say who, what?
Whose fault is
Oh, whose fault?
that?
It is, you could say it's my fault,
Oh,
but,
okay.
but I didn't need that. For 35 years, I didn't need that because the city and the townships will send a letter out saying it is time to renew your C of O. That's the red flag, or that's the flag and notice that I normally get. I've been used to getting that from the municipality of Pittsfield or City of Ann Arbor.
Okay.
Should I be burdened because they didn't do their job?
I don't know that, I don't think you're reading that correctly. If they don't send notice, then anything they do as to you, you might have a claim vis-a-vis you and the city or the municipality. The ramifications of that not happening still fall to you, particularly where you know every 2 years your certificate of occupancy expires. So the 6,231.01, why shouldn't that be credited to Miss Norman?
Well, that issue is not before the court in this case. That was resolved in the previous case. We had a consent.
What was resolved?
The previous case had to do with money issue and possession. She vacated the property.
While that case was going on, right? She vacated the property.
That's right. She vacated the property based on that consent judgment. The other issues on that consent judgment included money in escrow to pay for a water bill. That money was split between us. And that resolved the issues that were before the court at that point in time. You know, when this case was first brought before this court in Judge Barr's courtroom, she had brought this up about this previous thing, and that Judge Barr stated that we're not going to re-litigate the previous case.
And that's fine. And that's fine for Judge Barr. That can be his ruling. That may not be my ruling.
All right. Well, any issues of that money should have been brought up in that case. That case, if that was still a problem, or if she's claiming that she had a $3,500.
Why would I issue a judgment if she might be entitled to an offset?
I'm not sure. She should have brought up that she had a $3,500 deposit, which was not the case, that previous case resolved all the issues on that. One of the issues in that consent judgment stated there might be additional damages because at the time she still had possession, and I didn't know what those damages might have been at that point in time.
How much was your security deposit?
$3,500.
How much were your total damages?
The total damages,
Yeah.
$7,138.17.
So if she had a $3,500 security deposit, then we're really talking $3,500 at most here.
I don't believe she had a $3,500 deposit paid. She had paid
How much are you claiming her security deposit was?
$1,050.
You have that in a separate account.
No,
Do you? Why?
I don't believe I'm required to have that.
Oh, absolutely you are. That security deposit is not yours. So maybe instead of reading some Supreme Court case about something that is not tangential to this matter, you ought to look at the landlord-tenant statutes here, which would require you to hold that money separately because that money is not yours. That money is the tenant's money.
I agree.
Well, I'm glad. So where was that money held? When she paid her security deposit, where did you put that money?
Into my banking system, my banking,
I don't know what that means.
into my bank account.
And you used it.
Not specifically, I had a stockpiled in my bank account.
So how do I know how much her security is?
What I submitted to the court about her payments.
I'm going to repeat my question, so maybe I'll get an answer. How do I know what her security deposit was?
How do you know? Well, what's listed in the lease is not the amount that she paid at move-in.
What's listed in the lease?
The list in the lease was $3,500.
Yeah.
But she did not pay that when she moved in.
How do I know that?
Because the records of what she showed she paid.
How do I know she didn't pay it? The lease says she paid it.
The lease does not say she paid it. She does not have a receipt for that. I do have a receipt that shows